an opportunity to kind of work through it just right here while we're speaking. Because if I have to make the decision, I
Mhm.
don't know if everybody is going to like it. So I'll ask,
Enjoy the video, hit the like button.
do you all swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes.
Yes.
Thank you. You may lower your hands. So we're set today in a final trial in a suit affecting the parent-child relationship. The summary of requested relief is Petitioner's Exhibit 1, and it is admitted into evidence. Ms. Horton did not tender any exhibits today, and Mr. Craig did not tender any exhibits beyond that. Each of you have 15 minutes aside. That include any opening and closing statements, should you all choose to make one, as well as any examination. And the court takes judicial notice of all contents of the court's file, including the temporary order that is on file with the court and has been on file with the court since September 5th of 2025.
Thank you,
All
Judge.
right. Attorney Mitchell, at this time, would you like to make an opening statement?
I would not, Judge. I'll just call my first witness.
Okay. Ms. Horton, would you like to make an opening statement?
Yes.
Okay.
I'm Dorothy. My name is Dorothy Horton, and I am my son's primary caregiver, and I have been since birth. The only reason I'm here today is not to halt visitation. It's just to give safety precautions and parameters. That concludes my opening statement.
Thank you, ma'am. Attorney Mitchell, you may call your client.
Mr. Craig, please tell the court your full name.
Michael Eric Craig.
And Mr. Craig, you saw the summary of request relief that we tendered to the court, correct?
The from the email earlier.
Yes.
Yes.
Okay. And do you believe that what you're requesting is in your son's best interest?
Yes, ma'am.
You're still asking that the two of you remain as joint managing conservators of your son?
Yes.
Okay. And you're asking that you have a standard possession schedule with your son, correct?
Yes.
Okay. And right now the two of you are exchanging your son at the QT in Duncanville?
Yes, ma'am.
Tell the court how that's been going.
Well, I physically can't be there by 6 o'clock to meet to the demands of the paperwork, so I have a competent adult doing it. It's getting where it's hit and miss, where I don't get informed of information when we're running late. 5-10 minutes before pickup, I'm being notified my son is being sick. It's average that the average is about every 2 times that I go get him, the third time she may be on time. And it can be anywhere between 1 minute to 30 minutes, depending on. And only one time have I ever received a notification that she was running late.
Okay. And on the times that she's late by more than 15 minutes, do you keep your son an extra 15 minutes over the time that you're supposed to return him?
No, ma'am.
Okay. Would you ask the court to put those provisions in place so that you can have some provisions when Miss Horsley dropping off your son or picking up your son that you can get your time?
Yes.
Okay. Now, you're also asking for electronic communications. Is that correct?
As far as like
So that
the well-being of
so that you have telephone communications with your son on Tuesdays and Thursdays of each week from 7:30 to 7:45.
yes, I would like that if I
Okay.
can.
Okay. And right now you're unable to exercise your Thursday periods of possession due to the distance that you all live from each other, correct?
Yeah, I apologize. You'll have to excuse me 1 second. Now say that again. Sorry, I'm in my jobs break room.
Right. So, Mr. Craig, you're asking for these electronic visits, this telephone communications on Tuesdays and Thursdays of each week in lieu of your Thursday possession period because you're unable to exercise your Thursday possession periods, correct?
Correct.
Okay. And that's just due to the distance that you all live from each other.
Correct.
Okay. And right now, how do the two of you communicate with one another?
Court ordered to use app close.
Okay. And has Miss Horton been putting all of the child's information in app close?
No.
Do you have information with regard to your son's doctors and dentists?
No. I don't even have a social security number, birth certificate. Even when the opportunity just recently with my new job came up that I could get insurance.
Okay. Are you asking the court to order that Ms. Horton turn over that information to you on or before January 9th, 2026?
Yes.
Okay. And you're currently working at the same job that you were working at when we had our temporary orders hearing, correct?
Yes, ma'am.
Okay. And you're still making the same pay?
Yes, ma'am.
Okay. Are you asking the court to continue your child support at guideline child support, which you're currently paying?
Yes, ma'am.
Okay. And right now, Ms. Horton has health insurance for your son, correct?
I'm going to say yes. That's what she said in the court.
Okay. Are you asking that you have the opportunity to add your son to your health insurance?
I declined the insurance because I didn't know and it was too pricey at the time.
Okay. And so if Ms. Horton continues to carry your son on her health insurance, are you asking the court for you to reimburse her for the cost of the amount that she has to pay for him for his medical and dental insurance?
Yes.
Okay. And you believe that's in your son's best interest?
Yes.
Okay. Now, when we had our temporary orders hearing, Judge Lee ordered that you were to have some holidays and you were to celebrate your son's birthday, correct? This year.
Yeah.
Okay. Are you asking the court when is your son's birthday?
The 23rd
Of what month?
of February.
Okay. Are you asking the court to order that you have possession of your son on February 23rd for his birthday, since you have not had the opportunity to celebrate his birthday with him?
Yes.
Do you believe that's in your son's best interest?
Yes.
Okay. Now, all of the makeup time that Judge Lee awarded, you've already been given all of that makeup time back, correct?
Correct.
Okay. And moving forward, you're just asking for the temporary orders for you all to continue with the standard possession schedule.
Yes.
Okay. And but the only exception is for February 2026 for his birthday, that you have possession of him on that day.
Yes.
Okay. I'll pass this witness.
All right. Ms. Horton, this is now your opportunity to ask questions of Mr. Craig.
So as our son matures, how many days do you think you will be able to drop your son off or pick him up from school?
When it comes to that,
Yes.
if I don't have a competent adult, then I will figure it out to make sure.
Has your partner been doing every drop off since September 5th? Every
Objection
pickup?
relevance. Objection relevance.
Okay, ma'am, what's the relevance?
Big. I will have to say it's part of my testimony later as far as the temporary orders, competent adult being put in the orders when I didn't agree to that, and I didn't have a copy of the temporary orders prior to that hearing.
Okay, so I think I can make this easier for you.
Okay.
By law, as required by the Texas Family Code, a parent can designate a competent adult to do exchanges for them of the child. So you both are allowed to do that, as well as birthdays, because they already mentioned something about birthdays. So built into the law, it automatically has requirements for possession and access during the holidays in a child's birthday. So both of those things he is entitled to according to the law.
Okay.
Okay, so you can go on and ask your next question. I'm going to sustain her objection about the relevance to
Okay.
an adult.
Have you been paying guideline support on a consistent monthly basis?
Yes.
Have you been paying medical support on a consistent monthly basis?
No.
Do you think you've been flexible in our co-parenting arrangement?
Yes.
That's all the questions I have, Your Honor.
Okay, thank you. All right, Attorney Mitchell, do you have any other questions?
I have no further questions of this witness, Judge.
Okay, you may call your next witness.
I'll call Miss Dorothy Horton.
Okay.
Miss Horton, Go ahead and tell the court your full name again.
Dorothy Horton.
Okay. And Ms. Horton, have you been flexible in the standard possession schedule that's been given?
Yes.
Isn't it true that you've told Mr. Craig that you're not going to exchange the child and you don't care about the court's orders?
No, I didn't say that.
Ms. Horton, have you provided Mr. Craig with the child's health insurance information?
No.
Ms. Horton, have you provided Mr. Craig with the child's pediatrician or dentist information?
Yes. He has the pediatrician information.
Okay. But you've not provided him with a copy of the health insurance card?
No, not a copy of the health insurance. That's correct.
Okay. Isn't it true that Judge Lee told you that you had to provide a copy of the health insurance card to Mr. Craig?
Yes, that's correct.
Okay, but you still haven't done that, correct?
Yes, that's correct.
Okay. I'll pass this witness, Judge.
Okay. Any other witnesses, Attorney Mitchell?
No further witnesses, Judge. I rest.
Okay. Ms. Horton, this is now your opportunity to call any witnesses that you may like. You may call Mr. Craig, and you also may call yourself as a witness or as your only witness. It's up to you.
Okay. Well, I would, during my testimony, like to call me as my only witness
Okay.
available. Okay. So, as a witness to that, me and Michael have had issues ranging from personal to co-parenting. I will not deny that. I will not deny that I did halt visitation because there was a myriad of problems going on, including stating that I was trying to control him, not willing to come up with a parenting plan on my own, an unwillingness to pay guideline support in lieu of any order. Anything I said to him resulted in us getting into it. It got so bad that I did restrict him to email. February 2025, a week before he filed this case in court. I would like to also state that Michael put himself on child support, which is no problem with that. It would give me guideline support. But when they weren't moving timely enough, Michael went ahead and filed this case. I also would like to say that in our first March 21st hearing, I might get the date wrong, but it was our March 2025 hearing, that Michael, he has 2 DUIs. He admitted to drinking on the stand. He has not made any voluntary effort to be tested.
Objection, relevance.
Sustain. Go ahead.
Oh, okay.
But you can't go ahead with what you're saying, the
Yes.
last part of what you're saying, but keep going with your testimony.
Okay. And not having, me as a mother, not having those parameters in place has been very taxing. Our arrangement as far as custody, it's been at least 4 parenting plans since he was born. Our son was born. It was the first parenting plan was me.
Objection, relevance.
Sustain.
Okay. So we had 4 plans throughout our son's life. So a standard
Objection,
possession.
relevance.
Okay. The reason you keep getting that objection
Yes.
is because it goes outside of the scope
Oh, okay.
that you all are talking about. So, or what you all have discussed in terms of the case. So,
Okay.
I'll tell you this. You've heard what he said he wanted, right?
Mm-hmm. So go to that.
Tell me what it is that you
Got it.
or what you don't want him to have.
Okay. So I would like sole managing conservatorship.
Objection, outside of the scope of her pleadings.
Sustain. So that's going to be outside the scope because you never requested sole managing before today.
Oh, okay. I would like joint managing conservatorship with exclusive rights to major decision making.
Objection, that's outside of the scope of her pleadings.
Sustain. So you joint managing conservator.
Mm-hmm.
Okay. Let me do this. This will probably be easier for you. He requested joint managing conservators. You're cool with that, right?
Yes, as long as I get major decision making.
Okay, so let me just go down the list of what it is, and you tell me. He
Okay.
also, for you to be the person who designates the primary residence of the child in Dallas or contiguous counties, you're okay with that?
Yes.
Okay. For you to also receive child support.
Yes.
For you to also enroll the child in school.
Yes.
Okay. And then all other rights and duties are independent after meaningful conversation. So the two of you have a meaningful conversation of what you all are talking about doing with those other rights and duties. And
Okay.
then you still are flexible to make your own decisions. Are you okay with that?
I'm okay with that.
Okay. What about him having standard possession? Do you know what standard possession is?
Yes, ma'am, I do.
Okay. Are you okay with that?
No.
Okay. What type of visitation schedule are you asking for him to have?
Okay. I would like a modified schedule of every other weekend, not extended by in-service holidays. And I would like a reduced summer possession of 1 to 2 weeks.
And Judge, I'm going to object as that's again outside the scope of her pleadings.
Okay, sustain. I'm just going through with her what and
Yes,
I'm
sir.
taking note of your objections. I'm just going
Yes,
through a summary with her.
I
Um,
understand.
and he also testified that he's unable to do the Thursdays in person. So instead of those, he's asking for Tuesday and Thursday electronic communication. So they could be over the phone or it could be by Zoom at 7:30 and ending at 7:45. So for 15 minutes, those 2 days. Are you okay with that?
Yes, I'm fine with that.
Okay. You want to continue the exchanges at the QT?
No.
Okay. Where are you asking that the exchanges take place?
I'm actually, if I can ask for generic language, I've been stuck to under this,
You have to tell me what you mean by generic language.
like, non-custodial parent is to pick up child at a public area or public, I don't know how to put it, public
So
area by the home.
you don't want it designated.
Yes, that's correct. I'm sorry, Your Honor.
Okay, no problem, no problem. Okay, so let me explain to you the reason why the designation is so important.
Mhm.
So that's what makes it enforceable. That's a very specific place. Now, if you say you didn't like QT and you all wanted to change it to maybe Duncanville Police Department, right? That's a very specific place. It keeps down confusion typically. And if something were to happen for enforceability purposes, we already know where you all are supposed to be exchanging, so there's no confusion. Does that make sense?
Yes. May I ask one thing?
Yes, go ahead.
Okay, so I do want to look at the possibility of moving. So that's the only thing that I'm kind of on the fence about, the specific address. Like, would I have to, if I move, would I have to still come to Duncanville
That's
to
a
drop?
That is a great question, and you will. No matter where you all agree to, you will still have to come to that location. However, you do have because he's okay with it and you're okay with it, Dallas and contiguous counties. So that means you can live anywhere in Dallas County.
Okay.
And you can live in any county that touches Dallas.
Okay.
That's what that means. So even if you were to move, let's say you move to Ellis County, which is right there neighboring, you would still have to drive to the QT and do your exchanges. And the same goes for him if he were to move too.
Okay.
Okay. Let's see. A co-parenting app, you're okay with that?
Yes, we use app close. I'm fine with that.
Perfect. And I think it's a couple of more. I'll come back to that one last. I talked to you already about having the child on the child's birth, him having the child on the child's birthday. By law, he is entitled to 2 hours.
That's fine.
Okay. We cover child support. That is insurance. Go ahead.
May I speak on
On the child support?
Yes.
Go ahead.
Okay, so He was never calculated a guideline support for his income. He said he made $1,200 to $15 in our March hearing. He's right now paying $213. He's a mechanic. I am asking the court to impute his income.
Okay, so let me tell you how that works. In order for me to entertain a specific request, you have to do it based on some evidence, right?
Oh, I got it.
So the only evidence that I have in front of me is this temporary order that he should be a guideline child support. You didn't provide any exhibits, or no discovery was performed or conducted for me to know that his child support should be anything different. Does that make sense?
Yes, it makes sense.
Okay. All right. Did that answer your question about the child support?
Yes.
Okay. The last one I wanted to talk to you about is the healthcare providers. You have to give him the he has the pediatrician's information now, right?
Yes.
Okay. You have to give him an insurance card. If he's going to be the person who carries the health insurance, he has to have an insurance card. 9 times out of 10, he's going to need it for his employer. So you have to provide that to him.
I have no problem providing a card. My main, in a previous hearing, my only issue was that he lets people know my address. My company name is on my insurance card, like it's on a lot of insurance card. And all that I ask is that a redacted card is okay, and that I don't have to give my social out, because there's an issue there with privacy information.
None of that happens. I wouldn't order someone to social security number. The only socials that I do require are the children's social to have them, but he definitely needs an insurance card. And I just would hate for you to have to come to court on an enforcement, right, behind something as small as an insurance card. Just give it to him.
Oh, I am.
Okay. All right. Is there anything else? I finished going over the summary of requested relief. Was there anything else you wanted me to know?
Just that my son is 2 years old. He's about to be 3, and I just want him to be safe. And I'm willing to let a lot of stuff go, but I just hope the court consider his age. Some of the things that have been said today when determining order.
Okay. All right. And he's getting ready to be 3, right?
Yes.
Yes.
Yeah, he has a birthday coming up.
Yes.
So what I'm going to do, because it sounds like both of you are good parents. It sounds like you all care about your son very much. I'm not going to take that from either one of you. Good job, because if this is the most that I'm dealing with between the two of you, you all are doing good co-parenting. You really are. So I applaud both of you for working together. We just need you all to get a little bit closer in terms of co-parenting, okay? And I do believe you can get there, but you all have to show each other grace. So what I am going to do is I'm going to grant Mr. Craig's request in full, because as you know, you and I spoke, you were pretty much in agreement to everything. Now, this not to say for either of you, if something changes, something changes and it's considered material and substantial, you all are free to come to court to modify this order however you please, okay? So I don't want you all to think that, this is just set in stone forever. If something major occurs, you have the option to come back to court at any time. So I'm going to grant his request in full. And I'm going to have this summary of requested relief emailed to you, Ms. Horton, as well as you, Attorney Mitchell, and Mr. Craig. You'll get a copy from your attorney. The Attorney Mitchell is going to draft it out and make it into the legal form, like the temporary orders. Ms. Horton, you'll get a copy of it. You'll have an opportunity to review it, sign it if you want to. You absolutely can choose not to sign it. The only person's signature that matters on there is mine, okay? So I don't want you all to think that you have to sign the order once she circulates it, but you at least are going to get an opportunity to review it. And then once I sign it, you all, that'll be good.
Thank you, Judge.
I got a couple of questions.
Sure, go ahead.
As far as the first one is, as far as his birthday,
Yes.
for the day, since I'm getting for that day, his
Yes.
birthday falls on a Monday of a
Mhm.
weekend that is actually my weekend of visitation. So would I just, instead of returning him that Sunday, do I just keep him that Sunday and return him 6 o'clock that Monday evening?
Okay, so let me tell you what the law says, and then I'll tell you what Judge Vonda would suggest. Okay, so you said it's the 23rd, so the 23rd is that Monday. So according to the law, the first, third, and fifth week, you have to give him back that Sunday at 6 p.m. Okay, and then that Monday, which is his birthday, you will get him from 6 to 8. That's what the law says. Now, this is what Judge Vonda B would recommend, that the two of you co-parent through that and see what type of arrangement could you come up with. Mom, would you be willing to extend that having maybe extend it to him spending the night until the morning of his birthday and then returning him?
Well, the reason why I asked that question was because Judge Jean had granted me the full day with him on his birthday for this year.
For this year? Is it
Yes.
because the first birthday?
Yes.
Correct.
Okay. Let me do this. Mom, what is your opposition to that?
It was not in the temporary orders, both original and revised, and I do not want to do that.
Okay, so let me see. I'm looking at the temporary order. This is the most recent one from September, right?
Yes.
I think Judge Lee made an oral ruling on that part, and so we were just going by the fact that she said that he was supposed to have the child's birthday for 2026, and I don't think it was included in the temporary orders.
And I think I got to scroll back. I tried to highlight it on my tablet here. He missed last year's birthday, right?
That is correct, Judge.
Okay.
This was actually my first year to have him for a holiday period.
Right.
Or, excuse me, 2025 was. Excuse me. My apologies. I forget we're in 26 now.
Yeah, barely. We just got here. So, Miss Horton,
Yes.
what objection would you have to Dad having your son for the day of his birthday, since he didn't get him last year for his birthday?
What objections would I have? It's not in the temporary order or permanent order. I have tried to work with Mr. Craig. Mr. Craig has not been trying to work with me, so I'd rather just stick to the order, Your Honor.
So that's the temporary order. You all are in front of me on a final.
Yes.
So I could still do something creative for the both of you. What I'm trying to do is give you all an opportunity to kind of work through it just right here while I'm speaking. Because if I have to make the decision, I don't know if everybody is going to like it. So I'll ask like this, Ms. Horton, because he did not get him last year. Remember, this is his son too, okay? Would you be willing to allow Dad to have your son on the whole day for his birthday? And when I say whole day, I don't mean like you don't get to see him at all. Like if he could have him until 6 o'clock or maybe even 4 o'clock. He's not in school, right?
No.
No, Judge.
So if he were to have him till 4 o'clock and then you have him for until the rest of the time, because after that it's your time anyway. And this is just this year. We're not talking about 27 moving forward or anything like that. It'll default to what it is, but specifically for this year.
Your Honor, you can make your decision. To me, it's a day. My son needs to be taken care of every day of the week, so I'm not worried about a day. So go ahead and make your decision.
Okay, so this is what we're going to do. Dad is going to let's extend Dad's let's extend the child's birthday. So instead of dad turning over at 6 p.m. on that Sunday, dad, you're going to keep the baby until me give. Oh, it's little Michael. You're going to keep little Michael. You're going to keep him overnight. And then the next day at 3 o'clock, take him to mom.
Okay.
I think that's fair. So the both of you can see him on his birthday, and that's just for 2026. Moving forward, it'll be what it normally is, 2 hours during the birthday, okay?
Yeah.
But if you all decide to come to something different, you know, y'all may want to throw a big joint birthday party at Chuck E. Cheese or something, and y'all decide to do something different, you're more than welcome to do something different. I will not have any quarrel with that, okay?
Yes, Judge.
Okay. Well, that's it. Do either of you have any other questions?
No.
Yes, ma'am. Can I have the court request Miss Horton send a copy of the actual portion she pays of the insurance for my child? Proof of her, not just hearsay.
That was on our requested relief, so it was
Oh, okay.
requested that she provide the benefit information so that we know how much he has to reimburse.
Oh, yes. Miss Horton, you're going to do that, right?
Yes, I am.
Okay. See, we're not going to have any problems. Okay. Well, if there's nothing further, you all are excused.
Thank
Okay.
you, Judge.